Morning. This is actually a continuation of our November docket. We have one case that we have sent over for argument. Let me first introduce my colleagues. To my right is Judge Amy Klein. She joined our court in 2020 after a distinguished litigation career in Wichita. She's a KU law grad. To my left is the Honorable Rachel Pickering. She is the newest member of our court. She started in 2023 and had an extended career in public service in various places that I'll recount, most recently on the Shawnee County bench before coming here. She is a Mizzou law grad, which she reminded us of over the weekend with KU. I'm starting my 15th year on the court. I had a less than distinguished litigation career before that in various places across the state. I am a KU law grad, so I didn't appreciate the email very much. You may proceed.
Your Honors, as we sit here today, plaintiff has complied with the statute of KSA 12-105B when it served the county councilor of Sedgwick County. In 2020 and 2021, when we were pursuing this case, it was our understanding that through the employees of the county and through the regulations and the rules, that the board had delegated for the county councilor to manage all claims through a resolution, and that he could receive notice on behalf of the Board of Commissioners. Plaintiff is here because we are appealing the trial court's ruling of summary judgment in favor of the defendant. The court found that the plaintiff did not comply with KSA 12-10B when it served notice of the claims on the county councilor of Sedgwick County. It found that the Myers case was controlling.
Mr. Leroy, is it your position that you prevail only because the county had adopted the resolution and the procedure, in your view, designating the county councilor to receive notice, or is that alternative to your an argument that you substantially complied with the statute regardless by serving the county councilor?
No, we believe we substantially complied because of the resolution and that we served the county councilor. As you'll see, I think as we proceed, the whole distinction between every case that cited by the defendant and the Orr case, which we rely on, is that there's an additional step. In the Orr case, the courts found the additional step was that the superintendent by statute had been given charge and control of the school board. Here we have a resolution that allowed them to manage, and when talking to employees, as I think I've shown through the factual evidence, they believed that the county councilor was in charge and control of these type of claims. And therefore,
is that the equivalent of being the proper person to file notice with? I mean, simply the fact that you manage a claim.
Well, Your Honor, I practice here in Kansas, Arkansas, Missouri, and Illinois. What a lot of our generally practicing law, what we do is we call the county employees, they know better than us of, okay, who through the county do we send this to? Who's in charge? Who do we deal it with? And that's what we were told. Then we went and looked at the resolution, and the resolution says that he manages all of these claims. And so we were under the impression that yes, that we were complying. Now, hindsight 2020, should I have also sent CC the letter to the clerk? We wouldn't be here if I did. So hindsight 2020, absolutely. But when we were looking at it back in 2021, we absolutely thought we were complying by serving the board, which is what, in our view, the board has done is they've delegated the method of service to the county counselor.
I'm sorry.
No, go ahead.
Well, it seems to me that the section of the statute designating who you serve, the purpose of that is to avoid making the calls that you mentioned you have to make in Missouri and Arkansas, so that a plaintiff doesn't have to jump through a bunch of hoops to try to figure out who to serve, that they could look at the statute and clearly determine that. But you're asking us to say, no, actually, there could be other methods, and that seems to be counterintuitive to the purpose of the statute. Can you speak to that
Sure.
argument?
So the argument again, that in terms of the whole point of the statute is to give the county notice, right? And have the county know what's going on. That's why you have to list those 5 things, which again, there's no argument that our notice of claim was not deficient in terms of those five things. The issue there is that in this case, when we talk to the county, when we talk to the insurance adjuster for the county who I was dealing with, then when I talked to the EMS person, and then when my staff was talking to various clerks, everyone said you need to send this to the county counselor. The county counselor is the one that handles all of these claims. Then when you go and you look through the board of commissioners bylaws, which is so after the fact of being told that, you're going to see, yes, he manages all of them, manages up to 25,000. This is, I think you've seen in the briefs, but this is not like a bell ringer case where we're seeking millions of dollars. This is a broken arm case. There's a chance this case could have gone down for 25 or 60 or something like that. It all seemed to line up that serving the county counselor with this was sufficient. And then, I mean,
Can I stop you
Sure.
there real quick? You mentioned or as your persuasive case.
yes, sure.
2000 is when it issues.
Correct.
2006, Supreme Court visits this issue again in Myers.
Correct.
And it distinguished Myers, where they did serve the county counselor, from or, because in or, the superintendent had, quote, charge and control of the public schools. Quite different from the word manage. When you're an attorney, you're handling cases. You're managing the caseload. So speak to how you overcome the distinction between control and charge the superintendent has versus a county attorney who's managing the caseload.
So if we're talking the pure definitions, I would agree with you that there's a difference. But in the practice, as the way that we were seeing it through the employees saying that that the county counselor had charge, that he was in control, that he was the one to deal with these issues. Then when you go and read the statute, it says that he's managing them. It's purely that they're allowing the county counselor essentially to be the method of notifying the board of commissioners of these type of claims. He handles all the claims, managing them, and if he's handling them, it would make sense that he could be notified of it. That's the other point. The final standard point I think that I do want to just briefly touch on is looking at this is a question of law, and since it's a question of law, under the Myers Court and under the rules of Kansas civil procedure, you're to find that reasonable minds could differ as to the conclusions drawn from evidence, then summary judgment should be denied. And I think that's where the whole reason we're here is that there's an argument. There was clearly, there's an argument that the employees of Sedgwick County believe that the county counselor is in control. The resolution states that he manages all of them. We served notice believing we had complied with that, and then litigated this case for 17 months, going through various things. In that, yeah, I think it's clear they're relying on the text of the statute saying we should have served the clerk. Reasonable minds can draw different conclusions clearly from what the employees were saying and the resolution. The resolution is the key distinction upon Myers. Myers, there was no resolution. In addition, the additional cases cited by the defendants of Zephyr John. There, the Board of Commissioners had no resolution in Shawnee County, and Farmers Bank, Junction City, had no resolution. One of the questions, though, is the board, it is clearly Kansas law, the board cannot waive. They cannot waive service. There must be some type of service. And that's where, again, this resolution comes into play, because it tells them to manage the filed claims. You're filing the claims. They're telling him how to handle it. They're delegating how to handle it. How to handle something is far different than waiver. They're not waiving it, saying you don't have to do something. You don't have to comply.
Does the resolution also appoint the county counselor for service of process under chapter 60? By your theory? I mean, it says he manages claims made under 12105B.
Correct.
And he also manages lawsuits that are filed.
Correct.
Those would be under chapter 60.
Yes, yes.
And I mean, that is not, I mean, serving the county counselor is not an approved method of serving process under chapter 60.
And I agree, but so there it just says, it says for him to deal with the lawsuits. This specifically in that resolution states for him to manage the filed claims under the 12104B.
Well, and it also says he's supposed to manage lawsuits that are filed.
Does
that make him a proper person to serve process on under chapter 60?
I have not looked at what exactly you're supposed to go through chapter 60 in terms of who to serve.
Well, I can assure you the county counselor is not one of them.
What I would say there in terms of the distinction between the two is that the KCTA has very specific things of what you're supposed to do. And when talking to the employees, everyone believed that the county counselor was the person.
I understand that, but you're going back to the resolution and the policy that's attached to it.
Right.
Are you saying there's a distinction between filing notice under 12105B in that policy and managing lawsuits, and that doesn't make him, the county counselor, an agent for service of process? I mean, I'm not sure how you split that. It seems to me it's either both or neither, but
right.
That's what I'm trying to get at.
Right. And if I were arguing something to deal with 60 under the lawsuit, I believe I would be making the same argument based on the decision that it's been delegated. Again, the difference is that there is a resolution here, just like there was a statute in, or unlike in Myers, Zephyr John, and Farmers. I've only looked at it on the pertaining to this statute, but that would, yes, I would follow the same argument and follow the same line of reasoning.
Well, and I mean, it seems to me if we rule in your favor, that may be where we're getting at. I mean, it's not essential to this case, but it would be part of what we would be discussing or considering, I guess.
It would. I will say this. This does not clearly have blanket, this case in this ruling of the court, I believe, does not have blanket ripples throughout the state, unless there are resolutions and statutes that counties have put in place. And given the ambiguity at the time, if we're arguing whether managed equals charging control and things like that, the county board of commissioners can easily add in additional language to clear this up if need be. Well, we're looking at this hindsight.
Sir, don't we
Yes,
already have case law saying that the counties can't delegate about service already? Isn't there something about that already? That they can't just waive.
Correct.
This?
And
So under your thought, now, if we find how you want us to find, now counties can all start issuing resolutions. Correct? And so now
Sure.
we're going to be ignoring the complete wording of the statute that says that it must be filed in writing with the clerk.
well, I big difference. There's a distinction between waiving and as we wrote in our briefs, describing the method for service. So all they were doing here was delegating how to serve the governing body. It says you must serve the clerk or the governing body. And so here the way that resolution works is that the service, the board is essentially delegated the service and the managing of all the claims to the county counselor.
Okay.
You're going into your rebuttal time.
Okay, thank you.
Yeah.
May it please the court.
Mine's the one that counts.
This gives me an idea. May it please the court, Jerry Hawkins on behalf of the defendants.
Please proceed.
Sure. I've got my short outline. I got my long outline. I don't know which one to go with.
Why don't you go with the short one?
You want the short one?
I have
Okay,
questions.
unless you have some questions. Here's the gist of it. Did the county, well, first of all, we know that plaintiff argued to the district court that the reason why service upon the county councilor substantially complied with the statute is because this resolution gave the county councilor charge and control over all claims. They likened it to the or decision, and the response that we prepared is along the lines of what Judge Pickering has pointed out, is that that argument has already been attempted in the Myers decision, which was decided 6 years after or. They said, hey, in Myers, the county councilor has charge and control, therefore, they have charge and control, and therefore you should follow the or decision. And the court said, no, there's no charge and control by the county councilor. It's important to realize that when we talk about county councilor is an attorney. We're all attorneys in this room. The county councilor has to make a decision as to whether or not something that the county councilor receives is something that he should put on the agenda of the Board of County Commissioners meeting and docket and treat like a properly filed notice of claim.
Mr. Hawkins, the statute itself uses the term file as to how you give notice. You have to file the notice.
Yes.
Mechanically, how does one file a notice with the Board of County Commissioners?
In Sedgwick County, the way it works is the Board of County Commissioners is addressed a letter. That letter is then routed to their clerk, and their clerk files it in their system. So they keep a record of all claims filed either directly to the clerk or to the Board of County Commissioners.
Well, okay. I mean, but is mailing something filing?
Yeah, I think if you mail it in the mail, if you send it via email and it's addressed to them, I don't think that the statute, unlike the service of process statute, identifies the method of delivery to whoever you're sending it to.
Right. Well,
It does address to whom it needs to be filed with, but not the method.
Okay, and here, I mean, it talks about the governing board in the statute.
Sure.
Obviously, the Board of County Commissioners, which is 5 people, as I recall, in Sedgwick County, correct?
I think that's correct, yes.
I mean, can you just pick one of them to mail it to, or is it like a letter to Santa Claus that says to the Board of Commissioners on the letter? Or
The ones that I've seen have been addressed to the Board of County Commissioners.
Okay, I mean, that seems sort of haphazard to me.
That's the way the statute is written. They're the governing body.
I understand that. It almost would make sense to designate as an agent the county councilor to receive that for the board, since it's kind of abstract. I mean, is mailing it to one of the commissioners at their home sufficient?
What we have to keep in mind is that all of these positions are rotating positions, right?
Well,
County councilor is a rotating position. The governing body is a rotating position. The clerk is a rotating position. All of those present the same challenges in identifying the name of the person that you should send it to. But in lieu of even trying to figure out the name of the person that you can send it to, you can identify them by their title in your notice. So you could identify the Sedgwick County clerk and address it to the clerk and send it to the clerk without being on a first name basis.
So counsel, if somebody contacted the board or one of the board members and said, hey, I'm a layperson, I've got a claim, how do I serve my notice of claim?
Sure.
And basically you're saying the person who answers the phone is going to tell them, like you just told us, you can do this, you can mail it like this, you can mail it like that. Is that correct?
Yes.
So why
I'm
is,
not sure how much they act in, as a practical matter, how much legal advice that they give them, but they're not going to misrepresent who they send the notice to.
well, if somebody calls up and asks, where do I send it to? Is that legal advice? Or are they going to answer the question? Or they're going to say, I don't know, read the statute?
I don't know the answer to that. I think you'd have to ask the county counselor what advice they give the staff as a whole. Different governmental agencies have different advice or different policies about those kinds of things.
But they could give the same options that you gave us, correct?
Sure.
And why is that any different than the options that were given in this situation when we have the pre-suit letters, the demand letters, and they're being told, send it all to the county counselor? Why is that any different than my scenario or the one that you discussed earlier, where we've got all these different practical options to comply with kind of a vague statute?
2 points. One, I think that the emails and the affidavit that you have received in the record is there's some disconnect between what those things actually support and what was argued today. What was argued today is that they told him he could file his notice of claim with the county counselor, or he could send his notice of claim to the county counselor. If you look through those emails and you look through the affidavit, it doesn't support that. Second, if you find that it's a question of fact, or you find, well, maybe they did tell them that information, you still have to wrestle with the second question, which is whether or not the county has the power to designate someone other than the board or the clerk to receive notice. And that's the way that the Supreme Court handled the issue in the Steed case, rather than just get into the weeds of whether or not the county in that case had waived the 120-day provision or not. They skipped that issue and said, you can't waive it. It doesn't matter. And so they didn't reach that issue.
What about the substantial compliance question? I mean, isn't that a different issue? It could be substantial compliance if you're just following the directive of the county representatives that you're dealing with.
No, I don't think so. I think the substantial compliance standard per the Myers doesn't allow the creation of new methods of service. And the
Not new, but
substantial,
additional.
sure,
To create additional methods.
right. They can't create any methods of service other than those that are provided for in the statute. And per the farmer's case, they're not permitted to designate someone other than the clerk or the Board of County Commissioners as the person who receives the notice. So both of those cases, whether it's Myers or Farmers, you're blocked from doing exactly what was done here.
I guess I read those cases as saying you can't change the person that's designated by statute. That's always going to be a correct way to do it. But potentially you could have additional ways, like also serving the county counselor, having another option. Where is that barred in the statute or the case law?
Well, first of all, it's barred by the plain meaning of the statute. The statute doesn't say the clerk, the governing body, or your designee, or some other party that the county through local control adds. The plain meaning of the statute would not permit it. Second, the context of this says all claims, it says any claims, it's broad language that says it's the uniform procedure that's going to apply statewide. There's nothing in the statute that suggests that they've offered any local control to change this. The case law, on the other hand, also supports that they can't change it through the Myers decision that says that the court is not permitted to create new methods of service not included in the statute, in the farmer's case that says that they do not have the authority to change or add additional methods of service.
That was my, go ahead.
How do we recognize the reconcile the substantial compliance section of the statute then? That
What
kind
I
of
tell,
absolute dispute that you've just articulated.
substantial compliance, if you look at the cases from a 30,000-foot view, where the substantial compliance standard falls into or comes into play the most is regarding the content of the notice. But the substantial compliance doesn't come into play, as I read the case law, regarding things like the 120 days. Well, what about 119 days? Isn't that substantial compliance? The courts have stuck with the bright line rule that you need to comply with that rule. The persons upon whom they are served, we've cited all the cases that are on point. You've got the Orr, you've got Myers, we've got Farmers, we've got Steed versus McPherson area solid waste and others. And what you're learning from a 30,000-foot view of those cases is that the court is not going to extend situations like Orr in the future. You don't have in like most cases, you're not going to have a statute that has statewide implication. All school superintendents have charge and control over public schools. That would mean that all school superintendents can be served with a notice. That's a rule that they can live with. But having local control to make it willy-nilly and change depending on who, that puts the county counselor in the county in an impossible situation of having to know whether or not council has spoken to some staff member that said you can serve it in some other way.
So we have 105 counties here in Kansas. Think about how many municipalities we have. How many different rules of service would we have under that scenario?
We would have too many. It's much better if you're going to have a uniform system for payment of claims and only one appellate court that can only handle so many cases, to not have case law that is hitting you over disputes about whether or not an exception was created or not. These are difficult cases. I recognize the pressure that the notices and everything puts on everybody. And we don't want to create a system where subject matter jurisdiction, an important issue, should be dependent upon some fact question about whether a phone call or email could be interpreted one way or the other.
Yeah, and in this case, just to be clear, you're not claiming any actual prejudice here by the manner in which it's served.
No, and I'm not claiming actual prejudice other than that the county counselor receives this notice. The county counselor is aware of the Zephyr John, the Myers.
No prejudice in defending the claim or anything like that. I mean, apart from the legal argument you're making.
Yeah, the county counselor relies on the statute and the state of the law in deciding whether or not to present the claim to the board. That if there is prejudice, that's the prejudice. The second point is that I'm not finding anything in the case law that establishes that we're required in this jurisdictional question to show prejudice. The case doesn't turn on.
I just want to be clear. I mean, we're not talking, you're not up saying, oh, well, we lost all these defenses and we can't do this and we can't do that.
Yeah.
I mean, some people would call this a technicality. I mean, it is what the law is if it's your way, but it's not that somehow the county was impaired in how it would defend this claim if it had to, correct?
That's correct.
All right.
So back to the resolution, it says the county counselor manages all claims filed pursuant to 12105B, all lawsuits filed against Sedgwick County and all other matters. So the resolution, by including both of those things, is addressing who manages the claims post-filing. It's not addressing what happens before the filing of either a lawsuit or a notice. It doesn't address how or where to file the notice of claim. I don't know how plaintiff gets to the point of saying that somehow this designates the county counselor to accept service on behalf of the board as opposed to the clerk or the county, because it says nothing about any of that stuff either. It also doesn't say that there is some additional or preferred method of serving notice of the claim. If this had been their intent to have an additional or preferred method of serving the notice of the claim, then we would expect for the clerk to have received a notice that this was filed, as is their job, you know, so that's not in the record.
You've got about 90 seconds.
Sure. Sure.
On your short outline there.
Sure. At the end of the day, I think all of these issues turn on whether or not the plaintiff substantially complied with the statute, the motion to join, where I think plaintiff's counsel is blaming us for some things. I could respond to that if you have any questions about that, but we feel like we didn't have any obligation to file our motion for summary judgment any earlier or move to join the Board of County Commissioners.
So you didn't file a motion to dismiss either, because in your answer, you bring it up as a defense, but you never did a motion to dismiss.
That's right. We didn't file a motion to dismiss.
Okay, I just wanted to make sure I had
Yeah,
that on
we
the record.
checked and didn't feel like we needed to. We just denied the allegations that were relevant to the issue and then raised the defenses that we raised about 12105B and subject matter jurisdiction.
I do have one question on, I guess, on that second issue now that you bring it up. It's my understanding that your claim on the second issue is that they sued the wrong party. Is that correct?
Yeah, we said that they should have sued the Board of
Wrong
County Commissioners.
capacity? I mean, is this a 6209 issue, I guess is what I'm getting to, which requires you to specifically plead the defense that you've sued someone in the wrong capacity, and that statute requires you to raise the issue of the legal existence of an organized association of persons that are made a party, and you have to specifically deny that, which you didn't do in your answer. And the case law says that if you don't specifically raise that issue, that you've waived it. So what do we do with that issue in this case?
My impression is that this isn't one where they've sued in a wrong capacity. This is one where the entity that they sued did not have the capacity to sue or be sued. There are multiple cases that we've cited, Wright versus Wyandotte County Sheriff's Department. Wyandotte County Sheriff's Department is not a entity that can sue or be sued.
Doesn't that go with the legal existence?
Right, it doesn't,
Which is
a sheriff's department doesn't have the capacity to sue or be sued. And so all of these cases eventually get dismissed, but I don't think it's a 6209 issue.
But if 6209 requires you to raise the defense of the legal existence of the defendant, and you didn't raise that in your answer, and the case law says if you don't raise it, you waive it, why should we not find that you've waived that issue here? Just because you don't think that statute applies?
Yeah, I don't think the statute applies. I think this is whether or not they have the capacity to sue or be sued. It's also not an issue that you ever get to if they didn't properly serve a notice of claim, because at the point that they filed the motion to amend, they had not filed a 12105B notice then either. So the court still lacks subject matter jurisdiction. And I think that's why Judge Deborah Hernandez Mitchell found, our district court judge found, that the issue was moot. There's no need to get into these issues of the blame game between defense counsel and plaintiff's counsel about who should have raised what when.
Thank you.
Thank you.
Mr. Laura, you have your rebuttal time.
Good. Should I just set it for 2:30? I don't want to go. Can you give me a knock at 30 seconds or just let me know?
Yeah, you got 3 minutes, but yeah, I'll let you
I
know.
didn't
when
know
you
how
got-
much I went into it with.
No, go ahead. You got 3 minutes.
I think that it's getting lost a little in that looking at the cases, the way that they're cited and what they rule is the Myers court is clear. The court cannot create a new way to provide notice. Absolutely, that's correct. But there's nothing in the statute that says the Board of Commissioners cannot add a way to comply with the notice provision and to delegate. The resolutions are essentially, that's what they're there for. Going back to the beginning when the state started allowing counties and cities through the homeland laws to essentially how to create resolutions to help them conduct business and transactions to comply with the various statutes. And this is what the Board of Commissioners has done in Sedgwick County. The Steed case, the Supreme Court said flat out that the county can't waive it, and I agree. In this case, they didn't waive it. They directed a new way for it to be done. It's how to do it versus not doing it. It's a complete distinction. And I think that that's why the Orr case is controlling and that it's shown substantial compliance. The very least, again, this is a question of law under summary judgment. Summary judgment was inappropriate because when reasonable minds could differ as to the conclusions drawn from the evidence as to whether or not the law was complied with, summary judgment should be denied. Therefore, the court should have denied it. The final question I think is the ultimate question that you've asked, which is there are so many counties, so many cities. Wouldn't this create essential ambiguity and create chaos?
Right, and I asked it because I thought about the 4 states that you practice in, Illinois,
Right.
Missouri, Kansas. I mean, I just thought of you.
Well,
What would you practice?
and I appreciate that, but what I'll say on that is the Board of Commissioners is the one that issued this resolution. The Board of Commissioners, or not the Board of Commissioners, the county adjuster, uh, I'm gonna forget his name, but the gentleman who worked for EMS, that was the head of EMS, directed directed my staff and me to the county counselors. They are the ones that chose to institute these additional things. Yet it's my client who was punished. My client is ultimately going to be the one if summary judgment is again granted, where she's not able to recover on
You
her
have
claim.
about 30 seconds left.
Okay, on her claim. The fact that the statute still allows this to occur, there's nothing that says that it can't occur, that it can't be delegated in some way. And if that is what this case brings to light for the legislature, that they need to add that they can't delegate it in some way or provide additional method that maybe it'll come to fruition that you have to serve each board member or something along that line versus kind of what Jerry was talking about, where it's kind of sent generally to the board. Again, those are all ambiguities. This is just another ambiguity, and that's why the extreme result of summary judgment on this case should be reversed, given the fact that, again, there are different conclusions that can be drawn based on the resolution. Thank you.
Appreciate that we finally got this argument scheduled. Take account of what all you've had to say today. Interesting stuff. We will get out an opinion as soon as we can. And with that,